So we're on the record in docket 24-02611. That is People of the State of Michigan versus Philip Barham. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Shepard.
Good morning, Eric Shepard here on behalf of Philip Barham. We're both present in person in the courtroom, and Mr. Barham is standing to my right.
And sir, you are Philip Barham, is that correct?
Yes, Your Honor.
Thank you. This time set for preliminary examination today. Ms. Wilson, how we proceed?
Thank you, Your Honor. At this time, we're going to be requesting a preliminary examination, or we're going to be requesting an adjournment of the preliminary examination. One of my witnesses is not available today. Additionally, we're going to need a little bit more time in order to get the prelim done. At this time, we're requesting, I think, an afternoon, if possible.
That's the 21-day the 21-day rule was waived October 4th. My understanding this prelim is going to take some time. Is all the discovery done in this proceeding?
I did receive an additional discovery request late last night, and then I need to follow up with Mr. Shepard on a previous discovery request on some information that I received. So there is still some discovery that's ongoing, is my understanding.
All right. Is that a fair statement, Mr. Shepard?
It is, Your Honor. There was an order that you signed that was a subpoena that went out to Mr. Harris, the complaining witness in this case. He produced some documents in response to that. We believe that there are other documents that are outstanding in response to that. So Ms. Wilson's been working on that. I understand now that there's going to be a new prosecutor coming in. So Mrs. L, I believe it will be working on that as well.
All right.
And then there's a recording that is outstanding as well, that it just kind of came to my attention last night as I was preparing further for this case, getting ready to go for litigation process. And so I did put that in writing to the prosecutor's office, and I'm sure they're going to respond to that as well.
All right, Ms. Wilson, you'll make sure. I think it's Ms. Azell.
Yes.
She's going to be taking over, and then you'll make sure she has all the documents. And if she doesn't have the documents, she can make a record as well.
That's correct. Yes.
All right, and it appears this will be an afternoon prelim. Like we'll set some time aside for it, at least 2 to 3 hours.
Yes, there's quite a bit of discovery and evidence on this matter. So I think we're going to need some time.
All right, so preliminary examination will be set, and let me give you let's get some dates.
January 17th at 1:30.
So we have January 17th at 1:30. That would, and it is the 17th. That's a Friday, so that would clear that out. Does that work for your schedule, Mr. Shepard?
I could do that, Your Honor.
All right. All right, let's set for January 17th at 1:30 for full prelim. On this matter, and we'll expect both sides should be ready to go on that date, because we're moving it from today's date, but also we've got some discovery issues, and that should give Mrs. Zell enough time to get on. I'm understanding it's an embezzlement case, but she's got to get on board. All right. Anything else for the record in 24-02611? Ms. Wilson.
Not for the people.
Mr. Shepard.
No, Your Honor. Thank you.
All right. Thank you, Mr. Barham. We'll see you on January 17th at 1:30.
Thank you, Your Honor. Thank you.
Okay. Yep. And then I think we're ready on Shellington when the court is.
And Shellington?
Yes.
All right, so we're on the record in docket 23-03462. That is People of the State of Michigan versus Megan Shellington. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Robinson.
Aaron Robinson, Assistant Public Defender for Ms. Shellington.
And ma'am, you are Megan Shellington, is that correct?
Yes, Your Honor.
Thank you. This is the time set for preliminary examination today. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. It's my understanding that this is going to be a waiver of the 21 days and a request for an adjournment. It came to my attention, I believe it was earlier this week, that Ms. Shellington may be eligible for our diversion program. Unfortunately, the individual who screens for that is out of the office until Monday, so we're just going to need some time to get that screening done.
All right. Is that a fair statement, Ms. Robinson?
It is, Your Honor.
May I inquire of Ms. Shellington of her waiver of the 21-day rule?
You may.
Ms. Shellington, you understand you have a right to a preliminary examination today. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by Attorney Erin Robinson. She would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding it is your wish today to waive your right to a prelim within the 21-day period, have this case reviewed for diversion. And that'll give some time to buy the time that you would need to have this case reviewed by the diversion program. Is it your wish today to waive your right to a prelim within the 21-day period? You wouldn't be waiving your right to a prelim in general, just within that 21-day period.
Yes, Your Honor.
Okay. Ms. Wilson, do the people also waive their right to a prelim within 21 days?
We do, Your Honor. Thank you.
Okay, I find the waiver of the preliminary examination be knowing, voluntarily, and accurately made, and will reset for prelim and make sure that it's outside of that. So
I
2 to
would
3
say at
weeks.
least 2 weeks.
Okay.
How about
All right.
January 23rd at 8:30?
January 23rd at 8:30. So we'll reset this for January 23rd at 8:30. That'd give the diversion program time to look at the file and then continue on with the exam. Anything else for the record in 24-03-462, Ms. Wilson?
Not for the people.
Ms. Robinson?
No, Your Honor, thank you.
Ms. Shellington, you're all set. We'll see you on the 23rd.
One second. I have the notes for you.
Did you need to go down to talk to Dennis?
Oh, I've already talked to
Oh,
both
you
of them.
did? So,
Yep.
You want to bring up Denise Dennis?
please.
Slate, yeah, so if we could bring up Dennis.
All right. So Megan, if you bring up
Dennis.
Denise Dennis. Is that right?
It's Lisa.
She's gonna have to do a no contest plea though, because she was.
Okay.
To remember what happened.
Do we have a police report?
I can go get my computer, we can use that.
Okay. Is Ramsey caught it here?
I didn't see. I've been
Talking
talking
about
about
Brian?
Yeah. Let me go check.
And then I think we're ready on Brian.
Antoine Bryant?
Yes.
All right. Right, so we're on the record in docket 24-03644. That is People of the State of Michigan versus Antoine Bryant. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Coons.
And good morning, Your Honor. Dustin Coons for Antoine Bryant, who's standing here to my right.
And sir, you are Antoine Bryant, is that correct?
Yes, Your Honor.
All right, thank you. This is the time set for a preliminary examination today. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. It's my understanding that Mr. Bryan is in the process of retaining Mr. Coons. At this time, I believe we're going to be requesting an adjournment. I think that since Mr. Bryan, it does not have an attorney of record, if the court wants to find good cause, the people have no objection. This is a high severity felony, so I think it would be prudent for Mr. Bryan to have an attorney in order to proceed. And there is also quite a bit of discovery in this matter that Mr. Coons would need to review before being able to properly advocate for his prospective client.
Okay, thank you. Is that a fair statement, Mr. Coons?
It is, Your Honor, and just to give a little more context, I think we'll be filing our appearance today.
Okay.
Antoine's mother was able to retain us late yesterday, so.
All right. So for the following, the attorney was just retained or just paid to be retained. Although there have been some discussions concerning, I have on December 27th that there, at least the Kuntz Law Firm was being looked at, but it was just retained. And we want to give Mr. Kuntz the time to decipher all the information, all the discovery out there. And there does appear to be some discovery out there. So I'm going to find good cause to adjourn, so that Mr. Bryant's not waiving any rights today. And we will reset the prelim. I would indicate that Mr. Bryant is not in custody. And we're probably looking at 3 weeks.
I would say 3 weeks.
Yes. So Mr. Coons, check your schedule, but Is it still that January 23rd date?
Either January 23rd, or I could put it in on January 24th, if either of those work for Mr. Coons.
January 23rd or 24th?
Both are wide open.
Let's leave it on the 23rd.
Okay,
Is that the,
yes, that's it.
is that the Friday? Okay. So we'll set it for
Thursday, January 23rd at night.
Thursday, January 23rd at 9 o'clock. All right, so I find good cause to adjourn based on the attorney just being retained and should file an appearance today. And this is reset for good cause on January 23rd at 9 o'clock. Mr. Bryant, please keep in contact with the attorney, Mr. Coons, and discovery will be provided to Mr. Coons concerning this entire matter. Anything else for the record? 2403-644, Ms. Wilson.
Not for the people, thank you.
Mr. Coons.
No, thank you, Your Honor.
All right, you're all set. Thank you, Mr. Bryant. We'll see you on January 23rd.
Oh, hi.
The 9 o'clocks are, we gotta wait to call them, right? Except
Not
for
here
Ms.
yet? Okay.
Dennis.
Yeah, Miss Dennis is being brought up.
We have Fuller, Pettiford, and the rest are 9 or 9:30.
Yes, I believe Miss Pettiford is in custody, but Mr. Austin is speaking with Mr. Pfeiffer
Okay,
about Mr. Fuller right now.
perfect.
Did Megan go get Miss Dennis?
Yes.
Thank you. I just trying to figure out where we were at. And you said that's a misdemeanor, please?
Yes.
Miss
it is
Robinson
clear.
on a
Yep.
no contest, I think, right? A no
Yes,
contest.
that's correct.
Yeah.
Our printer's not working, so I had to use my computer. Hopefully that's okay, but I did highlight.
If you send it to me, I'll print it, Ms. Robinson.
I don't know if it lets us, our email lets us send it.
Oh.
Because it
Oh,
has.
yeah.
Because it
I've
has,
I've been kicked back when I try to
Yeah,
send
any,
police reports
any sort of
before.
protected information.
Oh,
like,
I had
okay.
that happen
The
yesterday.
county's VPN is like, no.
Yeah,
I think for purposes of plea, as long as you stipulate to the no
Yeah.
contest plea, I can review the police report. I'm gonna hand it back anyway.
yeah.
Oh, good.
Just gonna
point.
keep
Yeah.
the computer.
Yeah.
It's a good way to get a new one.
You know,
That
you
or
might-
it
she's not
catches
wrong.
fire in the middle of the courtroom. like
Yeah, that
early.
we're trying to avoid. Let's
I
not
don't
do
really
that.
have time for fires today, so literally fires, so maybe we could skip that.
That's one way to clear up your schedule.
That would clear the docket. The fire would clear the docket. Also
Yes,
clear the
but
building.
It's also cold out.
Yeah.
I'll just give this to you now, but I did highlight everything for
Okay,
you.
thank you.
Yep.
All right, so we're on the record in a docket 2403-652. That is people of the state of Michigan versus Denise Dennis. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson for the people.
Ms. Robinson,
Erin Robinson, Assistant Public Defender for Ms. Dennis.
and ma'am, you are Denise Dennis, is that correct?
Correct.
Thank you. This is the time set for a preliminary examination today. Ms. Wilson, how we proceed?
Thank you, Your Honor. It's my understanding that this is going to be a no contest plea due to lack of memory due to intoxicants. It will be a plea to an amended count 1 of attempted police officer resisting or obstructing. That's a 1-year misdemeanor and or 1,000, and a plea to count 3, the assault or assault and battery, the 93-day misdemeanor, and or I think it's 500. there is an agreement to no further upfront jail at the time of sentencing.
All right.
And upon successful plea and sentencing, count 2 would be dismissed.
So it's count 1 is the attempt R and O,
That's
which is
correct.
the 1 year and 1,000. And then count 3 is the A and B.
That's correct.
And that is 93 days,
Or 500.
500. Okay. This will be a no contest plea to both of these. With upon successful plea and sentencing, count 2, because count 1 is amended, right?
That's correct. Yeah. So count 2 would be the felony R and O, and it would be dismissed.
Is there any sentence agreements?
No further upfront jail at the time of sentencing.
Let me reiterate that for the defense, and then we'll confirm. This is a plea to the amended count 1 of attempted R and O, 1 year and $1,000. That's down from the original R and O felony. And then count 3 of A and B, the 93-day and $500. That is part of the information. With upon successful plea and sentence on those counts 1 and counts 3, counts 2 is to be dismissed. And there's a Killebrew agreement between the attorneys of no more upfront jail at time of sentencing. Is that a fair statement, Ms. Robinson?
It is.
All right. You understand, Ms. Dennis, that the no contest plea is punishable by count 1 is 1 year and or $1,000, and count 3 is 93 days and or $500. There is an agreement between the attorneys that you receive no more jail time upon sentencing. And if I was to do something different from that, you'd have the opportunity to withdraw your plea. Do you understand that, ma'am? Okay, thank you. All right, we have a no contest plea based on lack of memory due to any sort of intoxication or substance abuse. So I'm going to redo your trial rights in this matter concerning this misdemeanor plea. All right, ma'am? Yeah, you have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to have the witnesses against you appear at trial, to question any witnesses that are brought against you. You are represented today by Attorney Erin Robinson. She would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Do you understand that, ma'am?
Yes.
You have the right to have the court ordering witnesses appear in your defense, remain silent during the trial, not to have the silence used against you, and to testify at trial if you choose to testify. If this no contest plea is accepted, you'll give up the claim that the no contest plea was a result of any promises other than what's stated on the record, or threats that it was not your choice to plead no contest to the matter. You'd also be giving up the right to appeal anything from trial, since you'll be pleading no contest to counts 1 and 3, the misdemeanor counts, and you won't be having a trial instead. Is it your wish today to plead no contest to counts 1 and 3?
Yes.
All right. And we have pursuant to stipulation, I think this is the police report, and it is the Lansing Police Department report of it's case number 245-1911874, and this will act as a factual basis for the no contest plea. Is that my understanding, Ms. Wilson?
It is, Your Honor.
Ms. Robinson?
Yes.
All right. So we have on December 12th, 2024 at American Road, City of Lansing, Ingham County, State of Michigan. So date and venue have been made, location. All right, so I have that the defendant was approached by Jeffrey Kundrat And at that time, she offensively struck Mr. Kundrith. And that was not done in self-defense. That's the count 3. And the count 1, the attempt R&O would be the initial interaction with Lansing Police Department. Is that a fair? I think that's as I read it.
I believe so. I believe that in that interaction, there was a failure to comply with a lawful command.
There's an A and B, but there's also that there were some words said in between with the Lansing Police Department, and I would think that would be the same officer. Is that Brooks or Brown? I think it's Brooks that we're using.
I believe it was Brooks.
Okay,
I believe
yeah.
so. Yes.
And then at least that Miss Dennis was given a lawful command and refused a lawful command, as opposed, it was just a fray. It was kind of a fray there in the city of Lansing. Anything towards, so I find the factual basis, the attempt R&O and the A and B to be knowing, voluntarily, and accurate, a factual basis for both of those counts. Anything towards a factual basis, Ms. Wilson?
Not for the people.
Ms. Robinson?
No, Your Honor.
All right. I find the factual basis to be knowing, voluntarily, and act, well, it's a no contest, please. So I find the factual basis to be a factual basis for count 1, the attempt R&O, and count 3, the A and B. I'll return before you need a new. And we will set for sentencing. We will set for sentencing. I'm going to refer to probation. So probation will be down to see you, ma'am. All right. And then they're going to do a report, and that report will be present for me. And then we'll come back and see what options are available to us. All right.
Okay.
So we'll set for sentencing.
February 27th at 9:30.
At 9:30. All right, so we've set it for February 27th at 9:30. In the interim, you will be contacted by probation, and they will be there to see you, and then they'll develop a report for me, and we'll see what options are available to us.
And Judge, I would like to address bond today.
All right, you may proceed.
Yes, Your Honor, we would be asking for Ms. Dennis' bond to be converted to a personal recognizance bond at this point. I've talked to Ms. Dennis. She understands the importance of coming back to court and intends to do so. Further, she's had time to sober up since this incident, since being in custody, and understands the importance of remaining sober. She does have a place where she can stay, and she does believe that she can go back to work to where she was working at prior to the incident. So I believe that a personal recognizance bond would be appropriate in this case, especially since it looks like this will likely be a probation type of sentence.
All right, and how many days does she have in on this file? Is
She
that
was
from
picked up on
arraignment?
the day of the arrest.
All right, so that's December 12th to now.
Right. So I want to say about 3 weeks.
All right. Any comment on the reduction in bond, Ms. Wilson?
I would just ask that if there is going to be a PR bond, some kind of phone number or something be made available to Ms. Robinson in case probation needs to get a hold of Ms.
All
Dennis.
I have a contact number as a 517-505-0739. Is that still a good number for you, ma'am? Do you have an address that you can be reached at? Right now, I've just got a Holt Village Inn address.
817 North.
817.
North.
Spell that out for me, please.
North.
Oh, North. So 817 North. Is that, do you know?
Martin Luther King Jr.
817 North Martin Luther King
Jr. Boulevard.
Jr. Boulevard.
Right 915.
Ms. Wilson, are you aware of any CCH that would give this matter? Is there a prior CCH? Because I don't have one.
I don't recall one. I know that there isn't a habitual offender notice.
There is or is not?
Is not. So there's at least no prior felony convictions. I'm seeing some alcohol related priors, but nothing that I think
All right.
necessarily requires her to stay in custody.
All right. All right, I'm gonna grant the motion to, where are you working, ma'am?
Speedway, Jolly Dunkel.
And that's where you would intend to go back to?
Yes, I'm gonna go back and beg for my job back, tell them the situation and pray.
All right, with the updated address and phone number and a confirmation of the phone number, I'll modify bond for 5,000 PR bond. So if probation is not there to see you before you leave, you should contact probation and come in to see them probably, I would think, in 48 hours. So that would probably be, we'll say by next Wednesday. Okay. So see probation by next Wednesday in order to develop the report. If you don't see them by Wednesday, what they're probably going to do is ask for a bench warrant, and you'll get right caught in that bench warrant cycle. You want to avoid that, all right?
Yes, I will go.
So we'll set for February 27th at 9:30. It would, with the PR being sent, you will contact probation by Wednesday. And that would be February 8th or January 8th. See, February, yeah. January 8th. And then your sensing set for February 27th at 9:30. All right. Anything else for the record in 2403-652, Ms. Wilson?
I just have a nollie for count 2 if the court
Okay.
wants it.
I have nothing, Judge.
All right. Thank you, Ms. Robinson. You're all set, ma'am. Be in probation by Wednesday for them to develop a report, and we'll see you on the 27th.
Will do.
All right, thank you.
They're on the fifth floor of this building, so you just come here.
We're ready on Shelton. Yeah, Shelton.
She's just gonna waive the 21 days.
Perfect.
Have you received the calls yet?
Yeah, we just got them late
Okay.
yesterday, so they should be making
Because
their
I
way
just
over.
got the report, but I didn't like get any of the audio, so.
Gotcha. Yeah, it was like, I think it was like 117 files added to e.com.
Well,
So who are we going on?
Shelton's being brought on.
All right, that's Markel Shelton.
Just,
Ramsey Claudel.
Just got a hold of me, she forgot to charge the phone, which I've done. but-
Yeah.
And her alarm, she just woke up, she's
Okay.
gonna bust her butt to get.
Okay.
that.
I mean, she's not set until
9:30.
9:30, so
9:30.
she's got some time.
Yeah, my
Um,
anticipation is still that she's gonna get set, but
Okay.
I probably should wait until she actually gets
Yeah.
set on the record. She was walking.
All right, so we're bringing up Pettiford,
Shelton,
Shelton.
yes. And then I'm just gonna go check on witnesses real quick.
All right, and just let me know when you're ready.
All right.
All right. All right, we'll take 5.
All right.
There's no danger of that
After the heart
happening.
attack you gave me yesterday, I'm not standing for you.
Like, there's no danger.
Hey,
of that
Adam, what day?
happening.
Sorry.
What day is it?
Don't worry about it. Anyways, I knew the day of the week it is. It was in my calendar for the hearing. And then I was getting over something, so I was passed out.
It didn't have anything to do with the holiday before being passed out?
Legitimately not.
No, he was sick.
I don't drink. I don't,
He doesn't party hardy.
no.
Just because you don't drink doesn't mean you don't drink, so.
I
All right, Ms. Wilson, where are we proceeding?
We are ready to proceed on Pettiford and we are waiving her appearance.
All right, so we're on the record in docket 24-03-635. That is people of the state of Michigan versus Natasha Pettiford. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Austin.
Thank you, Your Honor. Good morning. Jared Austin appearing on behalf of Ms. Pettiford. She is not present in the courtroom, but she is present in the downstairs lockup.
And my understanding is she was in lockup this morning and we're waiving her appearance. Is that correct, Ms. Wilson?
That is correct.
All right.
I would agree with that, Your Honor.
All right, thank you. This is the time set for a preliminary examination today. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. The complaining witness in this matter has not appeared today. I did call and leave a voicemail with the date and time of this exam. Regardless, she has not appeared today and the people cannot proceed without her participation. I expect a motion from the defense.
Mr. Austin.
Thank you, Your Honor. Given that, I would ask the court to dismiss the charges against Ms. Pettiford, understanding, of course, the dismissal would be without prejudice.
All right, thank you. So I'm in possession of the order of acquittal concerning the dismissal without prejudice at the request of counsel's motion for dismissal without prejudice. It would appear the people are unable to proceed today. The complaining victim was not only subpoenaed, but left a message indicating the date and time of the preliminary examination and has failed to appear today. So at this time, the charges, the three charges are dismissed without prejudice. And Mr. Austin, you will explain to Ms. Pettiford that means that people could reissue if they choose to, but for our purpose today, the case is dismissed.
Yes, I will do that, Your Honor.
All right, I will sign the nollie pros accordingly. Anything else for the record in 24-03-635, Ms. Wilson?
Not for the people.
Mr. Austin.
Nothing additional by Ms. Pettiford, Your Honor. Thank you.
All right, thank you. That's all for the record in that file.
Thank you, Judge.
Thank you, Mr. Austin.
And then we have Mr. Sheldon.
Markel.
Yes.
Is he being brought up?
He's here.
Oh, Mr. Shelton.
So we're on the record in docket 24-03-677. That is people of the state of Michigan versus Markel Shelton. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Robinson.
Karen Robinson, Assistant Public Defender for Ms. Shelton, or Mr. Shelton.
And sir, you are Markel Shelton, is that correct?
Your Honor.
Thank you. This is the time set for a preliminary examination today. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. It's my understanding that this is going to be a waiver of the timeline. We did just receive about 117 files in evidence.com relating to this case. It's making its way over to the defense. They need some time to review it before we proceed.
All right. So is that a fair statement, Ms. Robinson? This is going to be a waiver of the 21-day rule for you to catch up on all the discovery. It
Correct.
Seems like there's a lot of discovery in this matter. Ms. Robinson, may I inquire of Mr. Shelton of his waiver of the 21-day rule?
You may.
Mr. Shelton, you understand you have a right to a preliminary examination today. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by attorney Erin Robinson, and she would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It's my understanding it is your wish today to waive your right to a prelim within that 21-day period. You wouldn't be waiving your right to a prelim in general, just within that 21-day period. And that's so Ms. Robinson can get all the discovery necessary in order to zealously represent you in this case. Is it your wish today to waive your right to a prelim within the 21-day period?
It is.
Okay. And Ms. Wilson, the people also waive the right to a prelim within 21 days.
We do, Your Honor. Thank you.
All right. I find that the waiver of the 21-day rule to be knowing, voluntarily, and accurately made. And this is really so discovery can be brought up for the representation of Mr. Shelton. And we will reset for
2 or 3.
I would say 3.
3, that to be safe.
Yeah.
Let's do 3. How many pages of discovery is there?
So the report's rather short. It's the audio and visual
Yeah.
that's gonna be a time consumption.
All right, let's go 3.
Can we do Friday, the 24th at 9?
Any issue with Friday, January 24th at 9 o'clock?
Not for the people.
No, Your Honor.
All right, we'll reset this. There's been a waiver of the 21-day rule, and we've set this for January 24th at 9 o'clock in order for all the discovery to catch up with the file and for council to be able to review the discovery. Anything else for the record in 24-03-677, Ms. Robinson?
No, Your Honor.
Ms. Wilson?
Not for the people.
All right, Mr. Shelton, we'll see you on January 24th. Thank you. for your time.
I lost Adam.
We'll find them.
Is there a Mr. Flores?
Or Torres?
Flores. FLEO. Yes, we can probably do that. There's
Alright.
no attorney on that.
All right, so that's Zion Flores.
That's correct.
All right. Is Mr. Flores, you can come up here. All right, so we're on the record in docket 24-03389. That's people of the state of Michigan versus Zion Flores. Will the parties please introduce themselves for the record, Ms. Wilson?
Abigail Wilson for the people.
And sir, you are Zion Flores, is that correct? Okay. And Mr. Flores, you do not have you do not have an attorney today, is that correct? Is that a yes or no?
No.
Okay, thank you. So Mr. Flores does not have an attorney. However, Ms. Wilson, how are we proceeding today?
Thank you, Your Honor. The complaining witness in this matter was not subpoenaed. However, I did attempt to call her yesterday. Her phone number is disconnected. We've had cases with these same individuals in the past in which she has not appeared. I do not anticipate her participating at this time. I'm requesting an ollie at this point.
All right, so we'll have a nollie printed out for your signature.
If you could grab that, please, Ms. Wilson.
Yes.
This layback is translated.
What this means, Mr. Flores, is that the people are moving to dismiss without prejudice, which means the people could reissue if they choose to, but for our purposes today, the case is dismissed. All right, sir? All right. You have any questions?
May I approach?
You may. All right, I'm in possession of the order of nollie pros on this file. The case is dismissed without prejudice. The complaining witness is not on board and has failed to appear. And I will sign the document accordingly. So this is dismissed without prejudice. And Mr. Flores, you should be all set. Thank you for your appearance today.
Does he have a tether? No. Okay,
Yeah, I didn't have any,
I didn't think so. I just want to make sure.
but Mr. Pfeiffer is full, right?
Yes. I think we're ready on Carcella's. That's just gonna be a waiver of the timeline.
Morning, Your Honor. Happy New Year.
Good morning, Mr. Yang. How are you? All right, so we're on the record in docket 24-03678. That is people of the state of Michigan versus Erica Carrizales. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Yang.
Good morning, Your Honor. Joseph King on behalf of Miss Erica Carrizales, who is present to my right.
And ma'am, you are Erica Carrizales, is that correct?
I'm Erica Olivia Carrizales, yes, sir.
Thank you. This is the time set for preliminary examination today. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. It's my understanding that the defense is looking to investigate an additional matter. Additionally, this is a co-defendant on the file that we just had where there were a substantial number of calls added to evidence.com that need to be reviewed by the defense and the people. So we are requesting a waiver of the timeline and an adjournment of this exam.
And is that a fair statement, Mr. Yang?
It is, Your Honor.
And then, so this is with Mr. Shelf.
That's correct.
But Mr. Yang, may I inquire of Ms. Carrizales as concerning her waiver of the 21-day rule?
Yes, Your Honor.
All right. Ma'am, do you understand you have a right to a preliminary examination within 21 days of your date of arraignment? A preliminary examination is a probable cause hearing in which people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by attorney Mr. Yang, but you have a first Joseph Yang, and Mr. Yang would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It's my understanding it is your wish today to waive your right to a prelim within that 21-day period, to have Mr. Yang get all the discovery necessary so he can zealously represent you in this file. You wouldn't be waiving your right to a prelim in general, just waiving it within that 21-day period. Is it your wish today to waive your right to a prelim within the 21-day period?
Yes, Your Honor.
Ms. Wilson, do the people also waive their right to a prelim within 21 days?
We do, Your Honor. Thank you.
I find the waiver of the 21-day rule to be knowing, voluntarily, and accurately made, and we will reset the prelim. And I'm assuming you want it reset with the co-defendant?
That's my hope. It completely slipped my mind that there was a co-defendant. I'm not sure if January 24th at 9 works for Mr. Yang's schedule.
Does that? All right, perfect. We didn't even think of that.
No.
But all right. So we'll set it for January. January 24th at 9 o'clock. All right, so please keep in contact with your attorney, Mr. Yang, concerning the January 24th at 9 o'clock. That'll be live on the 6th floor, City Hall of Lansing, and then we'll reset it for prelim at that time. Anything else for the record in 24-03-678, Ms. Wilson?
Half of the people.
Mr. Yang?
Nothing from the defense, Your Honor.
All right, you're all set, ma'am. Thank you for your
Thank you, Your
time.
Honor.
Two Schroders. And Mr. Milks.
I got a hold of Mr. Milks. He did
Yes.
not realize that this had been changed from 1:30.
So I asked him if I could request on his behalf if he could appear by Zoom. We're going to be requesting an adjournment, do some witness unavailability.
Sure.
Okay, I know his client is out in the hallway.
All right.
I'll let Mr. Milks know that.
All right. Yeah, because we moved a couple prelims. to the-
Yeah. Okay.
Yeah, it's in the hallway. I just was talking to him. He just tends to, I think.
No, I get it.
Let me, I mean, I'm just gonna be flat out, I'm gonna be doing requests, I'll take that. Do you usually gotta do it for cause or?
Okay, yeah.
That'd be my only thing, I'm bumping the entire thing over. Let me talk. to
Yeah,
him and
let me
see
know.
if he
Yep.
thinks-
Okay.
Like,
She just walked down
in the hallway.
She had a headband on.
okay, thanks.
Judge, we're not muted, just so you.
24-03-266. That is People of the State of Michigan versus Rennie Porter. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Schroeder.
Thank you, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Mr. Porter, who is present, standing to my right.
And sir, you are Rennie Porter, is that correct? Thank you. This is the time set for a preliminary examination day. Ms. Wilson, how we proceed?
Thank you, Your Honor. At this time, I'm going to be requesting a good cause adjournment. If the court recalls, we did file and the court granted a use immunity petition for the complaining witness. It's my understanding that there was a bit of a mix-up in his communication with the public defender's office initially, and he only just yesterday was able to get approved for a Fifth Amendment attorney. I'm not comfortable putting him on the stand without having been fully advised of the petition, the scope of it, and his rights under it. So at this point, I am requesting a good cause adjournment in order to get him someone appointed and get the ball rolling.
All right, and so the immunity grant was we signed that.
Yes.
That was done in relation to Mr. Porter, is that correct?
Lane.
Mr. Lane,
All
who's the complaining witness. Yes,
right, and that's we're waiting for the Fifth Amendment.
that's correct.
All right, is that a fair statement, Ms. Schroeder?
It is, Your Honor. I will just note that this case has been hanging out for a little while. However, I also understand the prosecutor's position. As long as it is attributable to the prosecutor or for good cause, I can't really come up with much of an argument regarding that. Thank you.
I do find that it's good cause to adjourn, and it would be attributable to the prosecution, but this case has taken a couple turns because of the petition.
Certainly.
There's an immunity petition that was signed, that was in December, and that had the talk of that good cause adjournment was from November 14th. I think this is a good cause to adjourn it, mostly just to get the Fifth Amendment and to read them all their rights and to make sure that the prosecutor's comfortable with the witness going forward in regards to the testimony, any testimony that they may have. So I'm gonna grant the good cause adjournment, and we'll reset the prelim. Ms. Wilson, how long do you think?
This kind of conflict counsel usually doesn't take too long, so I think maybe two to 3 weeks should be enough.
Yeah, it is conflict counsel, but it's a different type of conflict.
Yes, it's not for the full-blown case.
So 2 to 3 weeks.
January 17th at 1:30.
So we'll set it for January 17th at 1:30. So that it's set in the afternoon, so we expect some testimony to be taken concerning this matter. Fifth Amendment counsel will be ready for the witness, and we'll go on that date. Anything else for the record in 24-03-266, Ms. Wilson?
After the people.
Ms. Schroeder.
Court can just give me a moment here. I just want to make sure that I'm available on the 17th
Okay.
because I realize I don't want to get out of here and be like, oh, wait,
You also might be in trial.
that is my concern. That's why I know I have several that are coming up pretty soon. Okay, actually, that is a good, wait, no, it's, oh, I'm looking at the wrong.
53 violation as well.
Yeah, I have no idea why that's set. I haven't received anything. It was also set with a sentencing, which is
Yeah, that was
obviously not
bizarre.
applicable. So I'm not really sure what's going on there.
Okay.
And I don't have it set for,
All right, I'm gonna fix that.
Yeah.
Looks like I am good in the afternoon. So
All right.
yes, we are good.
so we'll set it for January 17th at 1:30.
Oh. That's, why does it, that
I'm
one,
working on it.
okay, we're looking at the
Talking about-
contempt thing here.
Oh,
'cause,
yeah.
Yeah, and it's.
So at this point in time, I don't have it on the schedule for the case.
I don't need, I don't.
Yeah,
Yeah, I'm not aware of anything. I think it might have been a clerical mix-up.
all right. So
Yeah.
it's just set for prelim on that date. I think the PA 53 is, I don't have it on the docket, so I think that's a clerical mistake.
All right, so do we need a new copy of the notice or do you want me to just scratch that out on his?
Just scratch that out on here.
All right, I can do that.
All right, so we've
Robert?
reset,
I just found 17th.
yeah, 17th at 1:30, same on the 6th floor, City Hall, Lansing, same as today's date. And that would give enough time for conflict counsel concerning this matter.
All right, thanks.
Thank you.
All right, you should be all set. Anything else on 24-03-266, Ms. Wilson?
Not for the people.
Ms. Schroeder?
Not for the defense,
You
thank
should
you.
be all set, Mr. Porter. We'll see you on that.
All right,
All right, sir.
we'll be in contact. Thank you.
All right.
Take care.
All right, thanks.
Feel better.
Yeah, that's right. You know.
I get it. I can appreciate it.
No, you're right.
Take care.
Yeah, I was
Oh, your book.
Thank you.
Thank
you so much. You're welcome.
That's a pretty.
All right, so are we ready on Fuller?
Yes,
Yes, Your Honor.
And then we have Glass,
yes, and.
Torres,
Yep.
and
Yeah, just if I may,
Mills is on Zoom now, Judge, just so
if I
Oh,
may,
he is,
very
okay.
quickly.
do you want to move Milks?
Yeah, we can do that real quick.
That'll be a pretty fast case. That's Torres. All right, Mr. Milks, and is Mr. Torres here?
Yeah.
You can come up here. All right, so we're on the record in docket 24027763. That is People of the State of Michigan versus Matthew Torres. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Milks.
And good morning, Your Honor. Stephen Milks on behalf of Mr. Torres. I'm appearing via Zoom. It's my understanding that Mr. Torres is there present in the courtroom.
That's a fair statement. Sir, you are Matthew Torres, is that correct? Yes. Thank you. This is the time set for a preliminary examination day. It was set for 1:30 and then we moved it to the morning. And that's some of the confusion that has come about. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. As I noted at the last preliminary exam, 2 of the officers in this matter that are necessary witnesses had some potential medical issues that were coming up, and we were waiting to see if that actually happened. It did. I've been informed that after the end of the month, people should be available for their medical leave. So at this time, I am requesting an adjournment in order to get them time to get cleared for duty.
Right. Both officers are on medical leave.
That's correct,
Fair
yes.
statement. Mr. Milks, is that a fair statement in your understanding?
That is my understanding, Your Honor. The people asked that in lieu of their testimony, if we would stipulate to phone messages. We are not in a position to do that. So we understand that this is likely going to be a granted adjournment from the people. I will just let the court know, I've got a scheduled vacation from the 23rd until the 29th at the end of this month. And,
all right.
And I guess one other thing, Your Honor, I'm not certain if Ms. Wilson is going to be taking this case still. My understanding is that there are going to be changes, so it's going to be a different prosecutor. Okay.
That's my understanding. Ms. Izell is going to be.
That's correct, yes.
Okay.
So she'll be assigned to the courtroom, but it shouldn't change the date in regard. But we will work around the vacation schedule.
Okay, thank you very much, Your Honor.
So, and then any discovery or any future negotiation should be in regards to Mrs. Zell.
That's correct, Your Honor. And we were planning on submitting some briefs for the objection that was raised last time. I do plan on completing that and submitting it before the next date. So that is still outstanding.
All right. All right, so we'll adjourn and we can adjourn, but before the 23rd, we can adjourn or after the 29th. It's up to you.
I believe Ms. Wilson indicated the officers would not be available
Till the end of the month.
Yes.
So it's got to have to be after the
If we
29th.
could have after February 9th, because I know another officer is out that first week of February.
Keith is already at over 110 days.
We have a good cause adjournment and a waiver of the 21-day rule on October 31st. But if both officers are out, I mean, we can start it with one, I guess. But so I'd leave it up to you, Mr. Milks, that we could actually start it with one, but we may continue with another officer who's still out. So if you want it completely past February 9th, we could start it with both officers.
Would a time before that be like the 17th, Your Honor, or January 17th?
I think that's too. I think we wouldn't have either officer ready on the 17th. They'll both be after your vacation on the 29th. Right now, I think they both probably be out the first week of February.
So I know that one officer is having an appointment today to get cleared. Another, my understanding is, will be available in February. And then there's a third officer who's just on a vacation that first week of February.
All right. So we could probably start the prelim anytime after the first clearance date.
Yes.
Okay.
Did you want to start the prelim and then go from there?
We can do that if one of the officer we had originally on the stand, her name's just escaping me right now. Officer Caitlin. Thank you.
Officer Markey.
Her testimony is sort of crucial regarding our arguments. So if nothing else, we could also just have arguments set for that day regarding
That's true.
All right.
If she would be present, because I don't want to.
So let's.
So she's the one that is freshly on medical leave, who I don't believe is available until February.
Okay.
So she's not available till February 9th.
That,
Or
no,
after
she would
February
be
9th.
available before February 9th. There's a third officer that's just on a vacation that first week. My understanding is that she's clear both the month of February and March when I asked about dates.
So we could set it in February for her.
We could.
Yeah. Do you want to do that as set it in February in regards to the officer and at least use that testimony for motion purposes?
Yes, that would work, Your Honor, I think.
All right. So let's do that. Let's adjourn and that we at least we keep the case rolling that way, because I don't want to lose, because this case is getting a little long in the teeth. But so we'll adjourn to the first week of February, right?
That's my understanding.
Yeah, that's
Okay, February 6th at 9.
February 6th at 9 o'clock for Officer Markey testimony. And we'll adjourn to that date for preliminary exam. That'll be at least the start of the prelim and also for motion purposes.
Very good. Thank you, Your Honor.
Anything else for the record? So we'll go to February 6th at 9 o'clock, at least for the Officer Markey's testimony. And anything else for the record in 2402-763, Ms. Wilson?
Not for the people.
Mr. Mills?
No, not for the defense. Thank you, sir.
All right, Mr. Torres, we'll see you on February 6th at 9 o'clock. All right, sir? All right, you're all set. Thank you, Mr. Milks.
Thank you, Your Honor.
Now we can go on Mr. Fuller.
Yes.
Got it. All right, so we're on the record in docket 24-03391. That is People of the State of Michigan versus Nicholas Fuller. Will the parties please introduce themselves for the record? Mr. Pfeiffer.
Yes, good morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Mr. Austin.
Thank you, Your Honor, and good morning. Jared Austin appearing on behalf of Mr. Fuller. He stands present to my right.
All right, and sir, you are Nicholas Fuller, is that correct?
That's correct, Your Honor.
Thank you. This is the time set for preliminary examination on the matter. It's my understanding we're having a prelim today.
Yes, Your Honor.
Okay, so are there any preliminary matters to come to the court's attention before we get started, Mr. Pfeiffer?
Yes, Your Honor. First, I want to place what the offer was on the record and the defense rejection of that offer. The defendant is facing 12 different counts as an habitual fourth offender. The offer was to plead guilty to a count of strangulation and a count of domestic violence and to dismiss the remainder. And it's my understanding the defendant does not want to accept that offer.
And that's a fair statement, Mr. Austin.
It's a fair statement of the offer, Your Honor. I did convey that to Mr. Fuller. He indicated to me he did not wish to accept that.
All right. With that understanding, Mr. Pfeiffer, any other preliminary matters?
Very briefly, I have Officer Trevor Allman here. The other officer who is subpoenaed, whose testimony I would need is Officer Ryan Brooks. For whatever reason, we have not heard back from Mr. Brooks. I mailed both of them last night. So my anticipation is to start and finish Officer Allman's testimony today, and then get a continuance in order to obtain Officer Brooks' testimony.
All right. And is that your understanding, Mr. Austin?
Mr. Pfeiffer did make me aware of that, Your Honor.
Okay, thank you. All right. So are there any sequestration orders to come to the court's attention? Is anybody in the courtroom that should not be watching another witness's testimony?
Not to my knowledge.
Okay, Mr. Austin, to the best of your knowledge, is there anybody who you wanted to invoke a sequestration order on?
Not to the best of my knowledge.
All right.
Your Honor.
All right, I'll leave it to counsel to let me know if anybody walks in the courtroom that should not be a party to the to witnessing another witness testify because of anticipated, they may also be a witness. And then I will entertain a motion to adjourn the matter after the witness's testimony. Anything else for the record? Mr. Pfeiffer, are you ready to proceed?
People are ready, Your Honor.
Mr. Austin.
I am as well.
All right, thank you. Mr. Pfeiffer, you may call your first witness.
Thank you, Your Honor. People call Officer Trevor Allman. He's using the restroom. He should be ready.
All right. Hey, Officer Allman, all right, you can come up here. All right, Officer Allman, I'm going to have you stand right in front of me and please state and spell your first name and last name for the record.
First name Trevor, last name Allman, first name Trevor, last name Allman.
Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
Right, go and have a seat. As you know, the microphone is for recording purposes, so please project to the back of the courtroom as best you can. Mr. Pfeiffer, when you're ready.
Thank you, Your Honor. Morning. Mr. Allman, where are you currently work?
City of Lansing Police Department.
And what's your role there?
Patrol officer.
How long you been a patrol officer at the Lansing Police Department?
So for 5 years.
Now, Officer Allman, were you working in that capacity on November 9th of 2024?
Yes.
And on that day, did you end up speaking with a Ashley Cooper?
Yes.
And what did you speak to her in regards to?
An assault that she was at Sparrow Hospital receiving treatment for.
So did you speak to her at Sparrow?
Yes.
What was her demeanor like when you were talking with her?
She was crying. I observed injuries to her face. And, her clothing was disheveled.
Now, as a result of talking with her, did you determine that assault had taken place?
Yes.
Did you determine that it was domestic in nature?
Yes.
Did you determine that it happened recently?
Yes.
And did the injuries that you saw on her seem to match up with what she told you would happen?
In my opinion, yes.
Thank you. You're gonna give them the fact. I believe that is sufficient foundation to proceed under MCL 768.27C. And I would seek to elicit hearsay testimony under that statute.
Thank you. Any objection to hearsay testimony coming in under 768.27C, Mr. Austin?
Oh, I don't know.
I do object, Your Honor. There's other factors that the court has to determine before making that. Now, I'm not really sure how the court can make that determination necessarily without hearing these statements. So I would have a standing objection. At this point, I would have a continuing objection to those hearsay statements. And I would just make an argument at the end. That's how I would anticipate.
All right. My understanding is the officer has indicated that the discussion led to an assault in nature. Okay, that's the first one. That this was a domestic assault, as the officers testified. He hasn't gone into the specifics of the assault, only laid the foundation for that being in regards that it was made at Sparrow Hospital at or near the time of the assaultive event. He took it at Sparrow Hospital. It was made to him as an officer. He's been a Lansing Police Department officer for 5 years, as he indicated, and that he also indicated that the events of the assault looked to be part of the treatment that the victim was seeking at the hospital, which would go to the trustworthiness. Response, Mr. Pfeiffer.
I think all the necessary foundational elements of 27C have been met.
All right. I will entertain a motion. I understand the continuing objection, and I will entertain an oral objection to the motion for 76827C. But at this time, I'm going to allow the witness to testify to the hearsay statements under 768.27C provided by the legislator, as this is not a trial, it's a prelim. And so there's no confrontation issue, at least now. That may arise later. So the objection is noted. It's overruled, and Mr. Pfeiffer, you may proceed.
Thank you, Your Honor. Now, Officer Allman, what did she tell you about the assault that had happened that made her be in the hospital?
She began her statement by telling me that he almost killed her. She went on to tell me that there was 4 different assault by strangulations. The first one, she described to me they were laying in bed. They had gotten into an argument about the past 2 months. She described him snapping and wrapping his hand around her throat and strangling her until she went unconscious.
Now, did she say where this took place?
In her bedroom at the house.
Now, that house, was that at 1215 Hickory Street, Lansing?
Yes.
That in Ingham County?
Yes.
Now, did she say when this all took place?
She couldn't give me a specific time. She said it happened at some point in time that day when the sun began to set.
Okay. Now, you were meeting with her the evening of November 9th, is that correct?
Yes.
So you said that there were 4 different strangulations, and this was all that day, right?
From my understanding, yes.
And the first one, she was laying in bed and strangled her.
Yes.
Okay. What can you tell us about, I just want to rephrase that. What else did she tell you about that first strangulation?
That she went unconscious, and when she had woken up, she was shaking.
What else did she tell you happened during this assault, this series of assaults?
She said when she had woken up after being unconscious from the first assault, at some point in time, either before she went unconscious or after she had woke up, the suspect told her that he had a spot for her body. Nobody would miss her.
Spot for her body?
Yes.
And she was telling you that she thought he was going to kill her?
Yes, she told me if she believed that if she didn't get out of the house that night, that she would kill her.
So what can you tell us about the next time she told you to put his hands on her?
They're still in bed, and she had woken up from that previous assault. They began arguing again, and he strangled her again until she went unconscious. And she said when she awoke from that, she was downstairs walking through the kitchen area. Suspect was following her. She told me that typically she doesn't fight back because the assault will be less violent if she doesn't fight back. But this time she was grabbed from behind by him, and she grabbed his hair during the assault. They end up being on the ground, and the suspect punches her in the face and strangles her again until she goes unconscious. She said she wakes up from that with blood on her face, and she's getting in the shower, assistance of the suspect to wash the blood off.
So he was having her get in the shower to wash the blood off?
From my understanding, yes.
So what can you tell us about, what did she tell you happened next?
She said once she's out of the shower, she notices he's busy with something, unknown what. She tries to make a run for it, out the door. He ends up grabbing her and throwing her on the couch, and he strangles her again until she goes unconscious. And she told me this time, the fourth one, she urinates herself during the assault and goes unconscious on the couch.
So 4 different times on November 9th, she says that she was strangled unconscious. Did she say, and she said she had blood in her face. What can you tell us about the injuries you observed on her?
I noticed her lips be swollen, some blood on her face and clothing, redness around her neck and shoulder area.
Now, did she tell you who had assaulted her during all this?
Yes.
And who did she tell you had assaulted her?
Nicholas Wolf.
And she tell you how she knew Nicholas Fuller?
Yes.
How did she know him?
She had been in a dating relationship with him for a couple of years. They had lived together in the past, but they've been recently separated for the last couple of months.
Now, did she give you information about the Nicholas Fuller who had assaulted her?
Yes.
And what'd you end up doing with that information?
I put it into our law enforcement information network to get a photograph of the suspect and any other valuable information.
And what's the reason you guys do?
To get a photograph of the accused, we know who we're looking for.
Now, do you see someone in the courtroom matching that photograph in the
Yes.
law enforcement network? And could you point out either where they're located, maybe something about them that differentiates them from the people nearby?
He's sitting next to a lawyer wearing all black, the black hair.
If
black
the record,
mustache.
if the record could reflect that he's identified the defendant and also that he pointed at the defendant?
Any objection to the witness identifying the defendant for purposes of prelim, Mr. Austin?
I can just have some brief word here.
You may.
Morning, Officer Ullman. So you said you were provided some information about this Nicholas Fuller from the person you were speaking to. Is that correct?
Yeah.
What information are we talking about? We're talking about full name, date of birth, height, weight. What do you mean by information?
I'd have to watch the body cam to go back, but full name, I believe, and maybe an age. I couldn't tell you 100% if she gave a full date of birth.
Was that an exact age or an approximate age, or do you recall?
I don't recall.
Do you recall if she gave you a middle name?
I don't recall.
Thank you, Your Honor.
And any objection to the witness identifying the defendant for purposes of prelim, Mr. Austin?
I'll leave it to court's discretion.
All right, thank you. So the witness has identified the defendant for purposes of preliminary examination. With that understanding, Mr. Pfeiffer, you may continue.
Thank you, Your Honor. Now, at some point, she told she was able to get out of there.
Yeah.
He had stopped her the one time for the fourth strangulation. But then what did she tell you happened after she regained consciousness after strangulation number 4?
She was able to get out of the house and run to Sparrow Hospital for treatment.
Okay, and then that's when you ended up meeting with her.
Yes.
Now, did she tell you if this was a one-off incident between her and Mr. Fuller?
No, she said that domestic assault happened frequently.
Your Honor, I would object to relevance.
I think it absolutely goes to the trustworthiness aspect of it, as well as the fact that it's admissible under 27 feet.
With the understanding that the objection is as to relevance, relevance is a lower standard. It's so I will allow it as to relevance. We're getting into a little bit of character issues concerning previous behavior, but for relevance, I think the witness's testimony is fine. So I'll overrule the objection.
And I will say that's as far into that category as I'm getting with just that one question.
All right.
Now, were efforts made to locate Mr. Fuller?
Yes.
What can you tell us about those efforts?
So she told me that he should still be at the house 1215 Hickory. If her car was there, he was most likely there unless he had gotten a ride. So me and a few other Lansing police officers responded to that house in an attempt to locate him.
Now, was he there?
Yes.
And what can you tell us about that?
So as we were arriving on scene, I was walking down the street. I wasn't sure which house it was going to be, so I flashed my flashlight in the front of the house to get house numbers, and I observed her blue Impala, I believe, that she had noted that was in the driveway. That was the house. So I saw the blue Impala. It caught my attention, and I saw a male exit the vehicle, match the description of the suspect. We had announced ourselves as Lansing police officers. The suspect got in the car and fled. We were not able to find the vehicle to engage in pursuit. So that was the end of the engagement at the house.
Now, I'm sorry, I lost my train of thought there. Now, did Ashley tell you he had permission to drive her car?
No, she said that he didn't have permission to drive the car.
So he got in her car and drove away?
Yes.
Now, who is there with you for that encounter?
This Officer Ryan Brooks and Officer Derek Selvin.
Now, you said that you saw someone matching the suspect's description at that scene. How good of a look did you get of that individual?
A fairly good look, but it was dark and I was pretty far away, and the way we were stacked on the approach to the house, I was in the back of the stack. So either Officer Selden or Brooks was in front of me, and I was kind of the third officer back as we're going down the sidewalk or going across the road. So I didn't get 100% good look at the suspect, but matched the description.
Now, is it safe to say that Officer Brooks would have gotten a better look at him than you would have that time?
Yes.
And also, what broad strokes, what time of day was it when you guys went out there?
It was definitely nighttime. I couldn't recall an exact time, but probably a couple hours or an hour after the original report.
Got it. Thank you. One moment, Your Honor. Your Honor, at this time, people have no further questions for this witness.
Okay, cross-examination, Mr. Austin.
Morning again, officer. So when you spoke with Miss Cooper, she was already at Sparrow Hospital, is that correct? Yes. Okay. And from what you could have observed, was she actively being treated at that time? Is that a yes?
Yes.
And were you dispatched there by the hospital, or did Miss Cooper call, or do you know?
I don't know who exactly called dispatch. I believe it was a nurse called. Like, typically, if an assault victim arrives at the hospital staff will call.
And when you arrived, were you by yourself, or were you working with someone?
I believe I responded to the hospital with Officer Ryan Brooks.
Okay. And this was the first time that you'd ever seen or interacted with Miss Cooper, is that correct?
As far as I know, there might be a time in my 5-6 year career that I've met her, but
none that you recall.
None that I recall.
And it's safe to say that you don't know any information that would relate to her mental health history, for example, is that correct?
Correct, yeah.
And you don't know if she was currently taking any type of psychotropic medications at that time, is that correct?
Correct, yeah, no idea.
And you have no way of knowing whether she was under the influence of any type of substances or controlled substances at the time she was speaking to you, is that correct?
Correct, I didn't review any blood work or drug tests.
And do you know if the hospital had given her any type of medication prior to speaking to you?
I have no recollection, or I don't know.
Okay. And was it your understanding from speaking with her that when these alleged assaults took place, it was just her and Mr. Fuller there at the residence?
That was my understanding.
So there, as far as you were aware, there were no other witnesses to this occurrence, is that correct?
Correct.
And your training is obviously in law enforcement. You don't have any background in medical training such as a doctor, nurse, or paramedic, is that correct? And given that this was, as far as you can recall, the first time that you'd interacted with Ms. Cooper, you can't say whether her demeanor that day was common or uncommon for her. Would that be a fair statement?
My opinion, she was crying. I mean, I can't see somebody crying like
Well,
that every day, you know what I mean?
Well, I'm not asking for your opinion. I'm saying you, maybe a better question would be, you have nothing to compare it to. Would that be a fair statement?
Correct.
Thank you, Your Honor. That's all the questions I had.
Redirect Mr. Pfeiffer.
Very briefly, just for a clear record, you said that when we went out there that day, there was you, Officer Ryan Brooks, and then you said there was another officer. Who was that?
I believe it was Officer Derek Selden.
Derek Selden.
Yes.
Okay, thank you. And then the only other question I have, based on your experience as law enforcement officer for going on 5 years now, did she seem to be under the influence of anything we were talking about?
Okay, so.
Or object to speculation.
It's noted as a speculation, but the witness can testify as to that moment in time.
Yeah.
And whether the witness appeared to be, in his opinion, lucid or not lucid, based on the fact that they don't have a history together. I think that's a fair objection. So with that understanding, I'm going to take the answer, the objection's overruled, with the understanding that this is just based on his conversation at the time with the witness. With that understanding, he's indicated he did not believe it, but you can re-ask the question if you choose.
No, I have nothing further.
All right, thank you. I might have missed it, so I'll ask the question and then provide any follow-ups. She indicated this was a domestic in relation. Did she indicate their relationship?
She said that they had dated for, I believe, 2 years, and they had lived together for a while, but have been separated for a couple months. Not living together separately.
All right. Do you have any questions concerning the court's question, Mr. Pfeiffer?
Not from the people.
All right, Mr. Austin.
I do not, Your Honor.
All
Thank you.
right, thank you. May this witness be excused from the people, Mr. Pfeiffer?
Nay, Your Honor.
Mr. Austin.
Yes, Your Honor.
All right, this witness is excused. Thank you for your appearance today. Any further witnesses today, Mr. Pfeiffer?
Erica, I have just one moment, Mr. Austin.
Sure.
So Ryan Brooks. The only testimony he can add is that's the face of the person that you saw. Like just for purposes of PE, not for trial or anything along those lines, to avoid us having to just come back for Officer Brooks. So that's, you guys want to stipulate to that, it can be done to IDs for that last bit there, where they were there, where the RNO is and things like that. I fully understand if you won't, but if you do, no worries.
Right, any witnesses today, Mr. Pfeiffer? Any additional witnesses today?
No, Your Honor.
Okay, do you have a motion for additional, for an adjournment in this matter?
Yes, Your Honor. The people would ask for an adjournment to obtain the testimony of Officer Ryan Brooks, particularly as it pertains to counts 6, 7, and 8. We heard from Officer Ullman here, who said that Officer Brooks had a much better look at the person who was there, that what he was able to see in the dark was a suspect matching the description of the defendant, of the picture that he found, and that drove away in her car from that residence. So while there is a lot of circumstantial evidence there for ID, and I think technically it could squeak by the probable cause standard, I believe that it would be more appropriate to have Officer Ryan Brooks here himself.
Okay. Any objection to the motion to adjourn? We've heard from Officer Ullman concerning the testimony, and then there's a request for adjournment as to Officer Brooks. Mr. Austin.
The only thing I would add, Your Honor, I understand that Mr. Fuller doesn't have a right to have his prelim completed within 21 days, only started, which is what has happened. But as it relates to the adjournment, the people's adjournment request to secure the additional witness, it doesn't sound like they've had any communication with this witness or no explanation as to why this witness isn't here. So given that, Your Honor, I would just preserve an objection on that adjournment request.
All right, thank you. The request for adjournment is granted concerning the testimony of Ryan Brooks. We have started the preliminary examination in regards to Officer Allman, who testified as a witness within the 21-day period. Do you have any notion of scheduling concerning Officer Brooks? I don't know his schedule and.
No, and I did not hear any reason for him as to why he's not here.
All right.
So I would not take that into consideration. I would
All right.
just find a date that works for the court.
All right, so we can set it. 2 weeks out, I would think.
2 weeks is kind of getting a lot of fatness to it. 3 would probably be better. but
I don't, yeah, that's, as long as it fits all the trial schedules.
Would January 23rd
January 23rd,
Sure.
at 9:30.
Mr. Austin, does that work with
Let me just check real quick, Your Honor.
so we don't end up rescheduling?
Thankfully, it will definitely be quick. I have very few questions for that man.
That would appear to work, Your Honor.
All right, we'll set it for January
23rd at 9:30.
23rd at 9:30 for a continuation on the preliminary examination for Officer Ryan Brooks's testimony. I have my notes that I've taken, and I'll provide that to the court recorder, and we can go from there. Anything else concerning 24-03391, Mr. Pfeiffer?
Yes, bond.
Right, you want to be heard on bond. I have bond set at 20,000 cash surety, and there was a
Yes.
bond recommendation done. Mr. Pfeiffer, you may proceed.
Your Honor, I think 20,000 is not sufficient for this case and for this defendant. He is facing 12 different counts for violent domestic crimes. And to top it off, he is beyond a half fourth. He's actually a half fifth. And I don't think that $20,000 is sufficient in order to keep the victim and the community safe, especially given the fact that the defendant has a history of fleeing from police, not only in this case, but in prior cases. I'd ask for $50,000, Your Honor. I think that that is far more appropriate for him, given the charges here in his criminal history.
Mr. Austin, a response.
Your Honor, I'm obviously opposing the people's request for a number of reasons. One, we're still in the middle of proofs here. This hearing hasn't concluded. We don't know what the ultimate outcome of that's going to be. But simply because the people believe that the bond is set too low, or they wish it were higher, is an insufficient reason for the court to modify bond. What the people are asking the court to do is to second guess the arraigning magistrate in this case, who, as the court indicated, had a bond recommendation form. There hasn't been any new information presented that perhaps the arraigning magistrate did not have or did not take into consideration when assessing Mr. Fuller's bond. There have been no allegations that Mr. Fuller has committed any bond violations in this case. There's been no allegations that he is not abiding by the no contact order. That is a substantial bond amount that he had to post. He had to post money. He is on GPS tether. He is being monitored by that. There is no reason to believe that he is not in compliance with that. He is reported to pretrial services. He has not failed to appear for any court hearings. So I don't believe that there's been any information presented that the court should essentially second guess and to say, if I were in the position of the arraigning magistrate, maybe I would have set the bond higher, which is essentially what the people are asking the court to do. I think it is sufficient to address any safety concerns and any concerns of non-appearance. And I think that's obvious because there hasn't been any allegations that Mr. Fuller is not compliant in any way with his bond. I believe it's sufficient as it is, and I would ask the court to continue Mr. Fuller's bond as it's currently set.
Thank you. Response, Mr. Pfeiffer.
Particularly in domestic violence cases, the fact that we haven't gotten any new reports or complaints doesn't mean that there aren't still safety concerns at play, given the fact that these are cases entirely about power and control. I mean, domestic violence going on for years, where he'd take what he wants, do what he wants, and she would not have any say in it, including whether or not he was able to use her car, use her home, things along those lines. Putting her in the hospital, strangling her 4 times in one day. And by the way, it's entirely appropriate for the court to address bond without there being any violations, without there being anything along those lines, because that's the job of the court to determine if bond is appropriate for the matter.
But this case presents a problem. I've heard testimony that's very serious testimony concerning this matter. This is not the first time. I believe that bond was relatively set at 20,000 cash surety by the magistrate for the allegations proposed concerning the probable cause determination as to count 1, count 2, count 3. I think we're in the 9 counts, if not into 12 counts. But there also was not, in addressing those 12 counts, I'm uncomfortable with the nature of the prior criminal history of the defendant, who doesn't come brand new. He comes with a criminal history. I have from pretrial services. I will indicate that facing, and I'm not sure he knew he was facing 12 counts. He knew these were serious allegations, that he terminated the interview with pretrial services. And that, according to the pretrial sentence report, the defendant terminated the interview, and therefore no bond was requested. By the pretrial services report, there's a prior history of a 2023 attempt R&O, a 2023 attempt R&O, a 2021 R&O, and then 2 drunk drivings out of 2017, 2014. So I think judging from the allegations made, it's a fair, but I don't think that the criminal history was included in that. And so I'm going to reset bond in this matter at 40,000 cash surety. So I'm resetting bond at 40,000 cash surety. It's also for I've heard testimony from one of the officers and the bond recommendation at the time, but I do not see anywhere where there was an indication of the prior criminal history. It's a hab forth on it, which is a fairly serious charge, and then we have a life offense, kidnapping, and the allegations are a 10-year for assault GBH.
Technically 6 life offenses.
Yeah, so that's the reason for the ruling of the court, is the prior criminal history. Mr. Austin, did you want to make a record?
Yeah, sure. I think certainly the arraigning magistrate was aware of at least some of the prior criminal history, given the habitual offender notice. And also, it's been my experience, having sat in and done many of those arraignments, is that the arraigning judge or magistrate usually has a copy of the criminal history of the lien and would have been privy to that. So simply because maybe the bond information report didn't contain that, I don't know if that's what the court was stating.
There's no doubt the magistrate had the criminal history, at least 3 priors and 2 drunk drivings, as a part of, but the bond recommendation was not made because due to the defendant terminating the pretrial services interview, which was for recommendation for bond. That was the nature of the report.
And so the only record then that I would clarify then, Your Honor, is that I think the arraigning magistrate would have been privy to Mr. Fuller's, criminal history and likely to the specifics of the allegations, probably from the swear to. Oh, and I'm sure the magistrate took all of that into consideration when setting the bond amount.
Thank you. The bond continues. The bond would be raised to 40,000 cash surety. Is bond set at this time based on protection of the public and prior criminal history. Anything else for the record in 2403-391, Mr. Byford?
Not from the people, Your Honor.
Mr. Austin, anything else?
Your Honor, thank you.
You're all set. So Mr. Fuller, you can go with my court officer for the additional bond amount, and we will see you on that January 23rd date.
Thank you, Your Honor.
Thank you, Judge.
Oh,
It's on the third floor here. It's on the third floor.
Megan, they'll have to bound out on the bit up here. They'll take a while for the paperwork to get through the system.
Okay.
So it'll probably be a couple of hours before anybody can call.
Okay.
Don't know if the picture can be a waiver or run that.
We still have Mr. Palmer and Mr. Schroeder.
Huh? And it's on video.
All right.
One second.
So Ms. Wilson, we still have Mr. Palmer somewhere on the sixth floor.
yeah, I told him to come find me when he was done with what he was doing, so he should be moseying around here soon.
And we have Ms. Schroeder also.
Yes, and I did release my lay witness on that case, after talking with Ms. Schroeder because of her client not being here.
Okay.
There's gonna be any additional.
Sounds like she's on her way, but she's been on her way for like an hour, so we'll see.
No, that was
Wait for
pretty
over an hour,
thoroughly
yeah.
charged up.
Which if she's taking the bus, makes sense, but
Yeah, we'll see.
Yep.
We've got time.
oh yeah,
Have a good weekend, Judge.
Thank you, Mr. Pfeiffer.
yeah, I cranked
Wendy,
those
happy to
out.
clear that up.
What's
You know, it's
that?
Friday.
I cranked those out.
You know, it's Friday.
Yeah, so I said have a good weekend.
Okay, you too. I'm just
I
checking.
knew my days of the week. I just didn't know what day the hearing
You
was.
will never, ever,
Absolutely not.
ever.
No.
Yeah, I know.
We were ready to call LPD.
I was convinced you were in a ditch somewhere.
Wendy was ready to do a wellness check on.
I was
Mr. Pfeiffer.
literally going to do a wellness
I
check.
was
I was
very,
starting to panic.
very unconscious. That's what it
That
was.
doesn't help. You could have
I
been
was
unconscious in a ditch.
I was unconscious in my bed, so
I mean, I was seriously actually worried about your well-being.
no, my calendar said that it wasn't until Friday.
Yeah, you're fine.
And I wasn't feeling well, so I'm like, I'm gonna be smart, take the morning for myself and
Yeah.
rest, so I'll be good to go on Friday. And then I wake up at 9:45 to a bunch of missed calls.
whenever.
You let me know when we're ready.
And we are on. Thank you.
All right, so we're on the record in docket 24-03-651. That's people of the state of Michigan versus Rashard Glass. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Palmer.
Thank you, Your Honor. Robert Palmer, the Public Defender's Office, on behalf of Mr. Rashard Glass, the gentleman standing to my right.
And sir, you are Rashard Glass, is that correct?
Yes, Your Honor.
Thank you. This is the time set for a preliminary examination today. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. The complaining witness in this matter did call our office and indicate that she did not intend to appear today. She has not appeared today. I did have officers here today. However, in reviewing the file, it's the people's position that we cannot meet our burden without the victim's participation. I expect a motion from the defense.
And is that a fair statement, Mr. Palmer?
That is a fair statement, Your Honor, and based on that, the defense moves to dismiss for lack of prosecutor's ability to prove probable cause.
All right, so I will be in possession of a dismissal at the defense motion based on counsel's representations to the court. The people are unable to proceed today. The complaining victim has been subpoenaed but has failed to appear, and there's been some contact with the victim indicating that they're not going to be involved in the process. So this means that the case is dismissed without prejudice. The people could reissue if they choose to. That's kind of the default. But for our purpose today, the case is dismissed. All right, sir?
Yes, Your Honor.
All right. I will sign the order of acquittal or dismissal. Anything else for the record in 24-03-651, Ms. Wilson?
Not for the people.
Mr. Palmer.
Your Honor, my client does have a tether from JSG. I would ask that the court contact JSG and let him know that the tether can be removed. I would also ask that Mr. Glass be provided with a copy of the NALI so that he can take that with him just in case he has any problems.
Okay, so we'll email as to the GPS for the removal of tether. And then we'll provide a second copy of the dismissal. I would just to be safe, give about a day for everything to purge from the computer system. So there'll still be a no contact order. I'd give a full day for it to all purge out, but you'll have the order of dismissal to be with.
As far as the tether as well.
Yeah, we'll email and you can go and get it removed.
Okay. Okay.
I'll explain all this to you.
Yeah.
Yes, sir.
So yeah, so you should have that removed as soon as you get down there, and you take the order of dismissal with you just in case. All right. That's all for the record in that file. Good luck to you, sir.
All right, thank you.
Thank you, Judge.
Then we'll do.
And then Ms. Ramsey Caudell is here.
All right.
Okay.
All right, Ms. Schroeder, you want to go on Ms.
Yeah, sure.
Ramsey Caudell? All right, so we're on the record in docket 24-03-088. That is people of the state of Michigan versus Chastity Ramsey Caudell. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Schroeder.
Thank you. An Assistant Public Defender, Aaron Schroeder, on behalf of Ms. Ramsey Caudell, who is present and standing to my right. No, it's okay. Don't
Right,
worry.
and ma'am, you are, and correct my pronunciation, it's Chastity Ramsey Caudell.
Yeah, you actually got
Okay,
it right.
all right, thank
I'm
you.
impressed.
This is the time set for a preliminary examination. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. It's my understanding that this is going to be a plea to an amended count 1 of retail fraud in the second degree. That's a 1-year misdemeanor and/or I believe $1,000 and/or $2,000. With the plea, the habitual offender notice is to be dismissed, and there is a sentencing agreement to no further upfront jail.
Okay, so it's a 1 year and/or $1,000.
2,000. I apologize.
2,000. And that is the retail fraud in the second?
That's correct. And I have the PAC code if the court would like it.
Sure.
It's 750.356D.
750.356D, 1 year and/or $2,000. That is an amended count 1. Is there any sentencing agreement?
No further upfront jail. And there is no restitution owed in this matter as all the items were recovered.
All right, so Ms. Schroeder, I'll reiterate that the sentence agreement as an amended count 1 to retail fraud second, that's punishable by 1 year and or $2,000 pursuant to 750.356D. And there's a Killebrew agreement of no upfront jail. Is that a fair statement?
It is, Your Honor.
All right. May I inquire of Ms. Ramsey Caudell of her advice and rights?
You may, Your Honor.
All right. Now, Ms. Ramsey Condell, you understand that the retail fraud second, the amended count that you're pleading to is punishable by 1 year and or $2,000. There is an agreement between the lawyers that you Killebrew no upfront jail, so no jail at sentencing or no further jail. Is that a fair statement?
That's correct, Your Honor.
All right. If I was going to do anything different from that, no upfront jail, you'd have the opportunity to withdraw your plea. You understand that, ma'am?
Yes.
All right. So you have the following misdemeanor rights, and I'll walk you through those rights. You have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to have witnesses against you appear at trial, to questioning witnesses that are brought against you. You are represented today by Attorney Erin Schroeder. She would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. You understand that, ma'am?
Yes.
You have the right to have the court-ordered witnesses appear in your defense, remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your plea is accepted, you'll give up the claim the plea was a result of any promises other than what we've stated on the records, that it was not your choice to plead guilty. You'll also be giving up your right to appeal anything from trial, since you'll be pleading guilty to the misdemeanor count. Is it your wish today to plead guilty to the misdemeanor count today?
Yes, sir.
All right. I'm going to have you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, sir.
I'm going to bring your attention back to April 29th, 2024 at the offense location of, is that Meyer on Pennsylvania?
Yes, the 6200 South Pennsylvania.
Okay. So were you at that Meyer location on April 29th, 2024, 6200 South Pennsylvania in the city of Lansing, Union County?
Yes.
And at that time, was Meyer open to the general public?
Yes.
And they had property for sale to the general public at the time?
Yes.
And you're responsible for taking property that you knew that didn't belong to Meyer that was open to the general public in the price of 200 to 1,000. That's a 1 year, 200 to 1,000?
Yes.
Is that your understanding, ma'am?
Yes.
Okay. And the property you took was valued at between $200 to $1,000, and it was not taken by accident.
I'm gonna say yes.
You took it on purpose.
Well, didn't scan it and I was in a hurry, but I mean, I'm gonna say yes, that I did take it on purpose so that
Okay.
I can take the plea.
All right. Well,
You
That-
can't be saying,
yeah.
you remember, you got it unless you're.
I didn't know that you can say, I meant, yes, I did take it on purpose, sir.
all right. So the prop I have, this is the indication I had that that you did not scan the property, and then the property was valued at over $200 for our purposes. Because I think the original price was a retail fraud first.
That's correct.
Okay. And that you knowingly attempted to leave Meyer with the property.
Yes,
Okay. After you didn't scan it.
correct.
Anything towards a factual basis, Ms. Wilson?
I'm just a little concerned about
The knowingly part?
yes, because I'm still not sure that we have the knowing and voluntary and accurate
Right.
plea as the mens rea.
So I will let Ms. Schroeder ask questions of the defendant if we want to clear that up, just to make it more.
Certainly. Miss Ramsey Caudell, you were at that location, correct, of the Meyer store at 6200 South Pennsylvania?
Yes,
And you had a variety of items that you're doing like a self-scan for, is that correct?
yes,
And some of those items you scanned and some of them you did not scan, could that be correct?
yes,
And but then the things you did not scan, you still put back in your cart to leave with, is that correct?
correct.
All right, and you did that you did that knowing that they hadn't been paid for, would that be correct?
Correct.
And you attempted to leave with that property, is that correct?
That is correct.
All right, now, Your Honor, prosecutor.
Okay, Ms. Wilson, anything towards the factual
The
basis?
people are satisfied.
All right, Ms. Schroeder, anything towards the factual basis? Based on your questions and the questions of the court.
I would just say that, Ms. Ramsey Cottle, we spoke at length about between emails, text, and
Yes.
here in person regarding this plea offer, correct?
Correct.
And I advised you of your various rights, is that also correct?
Yes.
And you are doing this of your own free will, this guilty plea?
Yes,
Because you believe you did something wrong?
I do.
Okay, thank you, nothing further.
Thank you. I find the factual basis for the amended count one to be knowing, voluntarily, and accurately made by the defendant will refer to probation. So refer to probation. So the fifth floor, go down. And I don't know who's gonna, but what they're gonna do is they're gonna develop a report for me.
Okay,
And then we'll go from there. We'll see what options are available to us.
okay,
right?
thank you very
So,
much.
so we'll set for sentencing on
February 27th at 8:30.
February 27th at
And
8:30.
that should be on that notice sheet. Janice.
Okay, awesome. I was gonna ask that.
Yeah, that'll be on the notice that you got from the court officer.
Oh, I see it. Okay, thank you.
So it'll be February 27th at 8:30. Anything else for the record in 24-03-088, Ms. Wilson?
Not for the people.
Ms. Schroeder?
Not the defense.
All right, I'll see you on February 27th at 8:30. Thank you for your
Okay,
courtesy.
thank
Thank
you.
you. All right, you're free to go. All
Okay.
right, thank you. Just remember, you might want to go down, I don't know if they.
I'm
close
gonna
for-
do it
They
now
don't
and
close
just
for
wait.
lunch.
Oh, they don't, but like go down to the fifth floor now and get checked in and get an appointment set up.
Okay, yeah, I'm gonna do that right now.
Sounds like a great idea.
Have a
See you
good
later.
day.
You too. Oh, that's fine. I'm good. Thank you, though. I appreciate it.
You're welcome.